meeting number 33 of the House of Commons Standing Committee on Health. Pursuant to the order of reference on May 26, 2020, the committee is resuming its briefing on the Canadian response to the outbreak of the coronavirus. We are meeting today for the purpose of debating the notices of motion in Mr. Genero's name. If a member wishes to intervene in debate, they should use the raised hand function. This will signal to the chair your interest to speak. In order to do so, you should click on Participants at the bottom of the screen. When the list pops up, you will see next to your name that you can click Raise Hand. So I have reviewed the blues, and members had agreed to withdraw the motions currently under debate in order to reconsider at a later date. I will therefore revert back to what had been agreed to by the committee as a starting point for our debate today. The committee had agreed to amend Mr. Genero's first motion related to Dr. Tam's appearance on May 19th, 2020, and the emergency stockpiles by deleting emails from the list of documents required. The debate is therefore now back on the main motion as amended. We will now open up debate on the main motion as amended, which means the main motion with emails removed. So debate is now open again. And I see Mr. Genero, your hand up. Please go ahead, Mr. Genero.
Thank you, Mr. Chair. I was under the opinion that we were going to move forward withdrew the motions in its entirety. If that's your opinion, that we are just starting from scratch, that seems a little sneaky, but nonetheless, I guess that's your opinion. So we'll begin the comments on that first motion. I won't bother reading it into the record, but for reference of the committee, it's the ones that we're looking at with regards to the wearing of masks, the advice that Dr. Theresa Tam had received. This has now been our 33rd committee meeting that we're now in, Mr. Chair, as you referenced in the opening remarks. Certainly, it's something that we're one of the first committees to start, and we're still ongoing. And we've heard a lot of testimony, that I think would really lay out the groundwork that this particular government was not prepared, lacked a sense of urgency, and even really quite honestly was boasting at how prepared they were. So the importance of these four motions today really highlight the fact that we need to make sure that we as a committee, and remember, Mr. Chair, we're separate from the government here, we as a committee get as much information as possible that we're able to then put forward a full and comprehensive report on advice for any other future governments, any other potential pandemics in the future. So being that case, wanting to make sure that we have all of that information available before us, I hope that the members of this committee will recognize that in these four motions that we go forward with, because it's imperative, I think, that for the protection of Canadians, we're as transparent as possible. No matter, you may be friends with the Minister of Health, you may be friends with certain members of the government, but at the end of the day, we as a committee have been tasked with finding as much information as possible for preparation for any other potential pandemics for the safety of all Canadians. And I implore upon the committee to consider this in the consideration of motions as we move forward, so we're as transparent and accountable as possible. Thanks, Mr. Chair.
Thank you, Mr. General.
Mr. Chair.
I see Ms. Jansen, your hand is up. Please go ahead.
Sorry, Ms. Sidhu actually had her hand up first. If she can go ahead first.
Very well. Go ahead, Ms. Sidhu.
Mr. Chair, I would like to add the following language regarding vetting by the department to all of MP General's motions, provided that the department does its assessment and vetting in gathering and releasing the documents as it would be done through the access to information process.
Just as a point of order, we can only amend the motion that's on the floor at this moment. Go ahead.
So should I go ahead, Mr. Chair?
propose your amendment as you wish it to be for this motion only?
Because we are proposing to amend this motion to apply ATIP rules, Mr. Chair.
Do you have specific language, please?
Yes, we do. Because that the department does its assessment and vetting and gathering and releasing the documents, and it would be done through information process.
Okay, so the amendment is in order. Is there any debate on the amendment?
Because we are following the same procedure, Mr. Chair, as prior Health Committee requests for production of documents. This is the same amendment and passed with both of the production of the document motions in the committee on June 15.
Thank you, Ms. Sidhu. Any further discussion on the amendment? Oh, sorry, I had this set up so I couldn't actually see that part of the screen. I have all kinds of hands raised now. I see Mr. General. Please go ahead.
Certainly don't support to that this particular amendment, Mr. Chair. If you recall, the last time that we had documents provided to us, they were blacked out substantially, and a bunch of information that would have been helpful, I think, in the preparation for the government and quite frankly for Canadians to understand in the lead up to this pandemic. It's likely in that blocked out information. By attempting to apply the ATIP rules, we're separate from government. We're a committee. This is a committee made up of parliamentarians. It's actually quite shocking that this is the attempt by the government to hide this information even more. We simply want, as a committee, I think, to get to the bottom of this, to really fully understand what the advice was being given on some of this information, and to simply block out. I question why Ms. Sidhu would not want this type of information available for her constituents, for her own information, quite frankly, because at the end of the day, this is information that we need to prepare for any report that we want to provide for future governments, for future potential pandemics, that we want to make sure we have as.
Mr. Chair, may I?
Hold on, Mr. General still has the floor.
I'll wrap up, Mr. Chair. Oh, sorry. I'll wrap up, Mr. Chair. It's again, it's shocking that this is the attempt. In light of everything that's happened in the last week, I would implore this particular member to withdraw this amendment because the transparency is obviously what Canadians are looking for these days, and this is just another attempt to hide that.
Thank you, Mr. General. Ms. Jansen, I apologize. You were actually next. Please go ahead now.
Oh, that's all right. Thank you. I'm extremely concerned. I've really found this committee work fascinating. And I thought that the idea was that we would be able to give Canadians a truly good picture of what happened and the types of reactions that were done. And I think it's so important. Canadians are scared. If we want Canadians to not be afraid, we need to ensure that we provide them with a really wholesome amount of information. And if we black stuff out, which some of the documents we received via ATIPs happened, if we black stuff out, it's very concerning to Canadians because then it looks like there's something to hide. We need to make sure that it doesn't even appear that we're trying to hide something. So yes, I would also urge and beg Ms. Sidhu to remove that change, because Canadians are scared, and we owe them that we are completely open and transparent so they understand exactly what happened and why it happened, so that they can once again feel confidence in the process.
Thank you, Ms. Jansen. Dr. Jaczek, please go ahead.
Thank you so much, Chair. Well, I'm going to be supporting Ms. Sidhu. Whenever we request information, it's really important to balance it with the natural privacy concerns of those involved in providing the information. I think this committee already has approved similar language. It was not the subject of much dispute previously, and I fail to understand why at this particular moment the privacy aspects are apparently willing to be ignored by the couple of members from the committee who've spoken so far. And I think we also need to be cognizant that this material will require information, access to information, potentially from other levels of government, and certainly in terms of privacy issues for those other levels of government's personnel involved in gathering this sort of information and providing this information. Their privacy rights need to be respected. So I'm definitely going to be supporting Ms. Sidhu in her proposed amendment.
Thank you, Dr. Jaksic. We'll go now to Ms. Kwan. Ms. Kwan, please go ahead.
Well, thank you very much, Mr. Chair. I'm subbing in for MP Don Davies, so thank you for the opportunity for me to speak to the issue here. With respect to the amendment, it is my understanding that through the last round of the request, a similar request was made through to the committee. Much of the information did come back redacted, and I think that it is of concern if we're trying to access information, the sharing of the information to the public. I think that, and that's certainly is the case with other committees and my other experiences, and that is on the issue around privacy information in terms of names and phone numbers, emails, and so on, that the privacy component can address those issues in terms of ensuring that people's privacy are respected. But I'm wondering whether or not really is the department officials who should be doing that work, or should that be done elsewhere with respect to the privacy component? And so, and the other two aspects that I know in other committees where they look at in terms of information, the sharing of information, deals with national security and then cabinet confidentiality. So those are the only two other aspects that would apply. So I'm not quite sure in the language of this amendment if it's referring to that normal process in that regard, or are we talking about something greater? And since this language was used before with previous requests for information and much of the material came back redacted, it would be hard to imagine that all of that stuff is to do with people's privacy in terms of the name and contact information. So I would really want to highlight that and urge the Ms. Sidhu to reconsider this aspect, because if this motion is really, or this amendment proceeds as the way it has previously, then I think it defeats the purpose of ensuring that the information is made public and accountable to the public.
Thank you, Ms. Kwan. Mr. Fisher, please go ahead.
Thank you, Mr. Chair. And the privacy and the things that would be or should be redacted because of this amendment or this proposed amendment, imagine conversations between a province or a territory. Imagine names, ministers, public figures. I think it's important that we consider the privacy. I guess I get what MP Kwan is saying. It's important to ensure that the proper people are vetting this, but the language that is used by MP Sidhu is the exact language that was put forward by, and I read this and Matt got a great chuckle out of this last time, but these motions, this wording comes from conservative motions. John Barlow moved that given the Department of Agriculture and Agri-Food's written response to MP Philip Lawrence's question on the cost of the carbon tax to the agricultural industry, in which their analysis and estimates do not reflect the federal backstop, the committee send for a copy of all reports, briefing notes, memorandums, and documents related to the federal carbon tax and its cost, directly or indirectly, to the agriculture industry, broken down by province, to be provided in both official languages by Saturday, August 1st, 2020, provided that the department does its assessment and vetting and gathering and releasing the documents as it would be done through the access to information process. So when we hear this angst about keeping things from the public, this is strictly about privacy and relationships and discussions. So another one, Kelly Block moved. Then in the context of its study of the government's response to the COVID-19 pandemic, the pursuant to Standing Order 1081A, the committee send for the following documents to be provided by the government on Monday, August 3rd, 2020, and that the documents be published publicly on the committee's website by Monday, August 10th, and that departments tasked with gathering and releasing and following documents do their assessment and vetting as would be done through the access to information. There are more. There are many of these, and they all appear to be conservative motions. So I'm not sure why folks are up in arms on this, but I will agree with Jenny on this, that it's important that any vetting that is done be the proper vetting for the real reason of privacy. I share her concern about making sure that too much is redacted and that the right people do the redacting. So thank you for that, Mr. Chair.
Thank you, Mr. Fisher. Go now to Dr. Kitchen. Please go ahead, Doctor.
Thank you, Mr. Chair, and thank you for everyone's input. With all due respect to Mr. Fisher, what was proposed back at that time, which was a number of months ago, we've since seen what has come out of that and the information that's been provided or has not been provided. And the redacting of that information basically left the thes and the tos and the ins in, but took everything else out. And that's challenging. When we turn to Payne, who said in the article in Toronto in the Star on April 3rd that, basically, I had to negotiate the landing slots of our planes to land in Peru. I did that by text message, to be honest. And then the minister at our meeting, on meeting number 30 on June 23rd, 2020, basically said, we did diplomacy by text message. I managed to get people out of Peru by texting my counterpart there and negotiating landing rights. We got people out of Morocco by texting the minister and saying we needed one more flight. This is information that has been put out there that we hear after the fact, after it's all been redacted and taken out. So I truly do
Point of
hope...
order, Mr. Speaker, and I'm sorry, Dr. Kitchen, sorry to interrupt, but those motions that I just read, which were moved by Conservatives, were for documents that have not even been produced yet. Those are for August production documents, so they're not old. That's not in relation to the one that you're talking about that came back already previously redacted.
Correct, and the reality was redacted. Why? Because of ATIPs. So for you to suggest that that's not the case, and then we have to wait to see what the ultimate response is, I think is a little misleading. So ultimately, I would ask Madam Sidhu to maybe reconsider this motion.
Thank you, Dr. Kitchen. We go now to Mr. Kellaway. Please go ahead.
Thanks, Mr. Chair. I'll certainly be supporting the amendment being posed here by MP Sidhu. We talk about the importance of transparency, and I think everyone would agree with that. Every Canadian would agree with that. Everyone on this panel, every staff member would. But I also think that there's two other elements that go with transparency, and that's efficiency, and that's also consistency. And I look at Mr. MP Barlow or MP Block, and if it's good for those folks, I think that it should be good for us in this case. So I think you can have all three elements: transparency, efficiency, and consistency. And I think we can walk and chew gum at the same time.
Thank you, Mr. Kellaway. We go now to Mr. Ginro.
Thank you, Mr. Chair, and through you to MP Fisher. The comment on imagine names and public figures were to be released. Quite honestly, that's why we are public figures for that purpose. The Minister of Health has a tremendous responsibility in making sure that she is accountable to Canadians and to quite frankly the opposition in this case, and that's what we're trying to get to the bottom of. The motions that Mr. Fisher references were apparently agreements made offline. I certainly wasn't privy to any of those being asked of us here at HESA. Means we don't have to do that. Nobody has approached me to make any of these sorts of deals offline either. So Mr. Fisher, they're not necessarily pertain to here. I simply implore the committee. We've worked extremely well together. We've heard of a lot of very, very important testimony. In light of everything that we've heard and the the consistent just lack of preparedness and readiness for this pandemic, I think Canadians will certainly would appreciate the ability to know that this government has perhaps learned lessons, is looking forward to implementing certain things that maybe weren't in place from before, and that's fine. We want to make sure that we have those as part of our report, so that can then become a lessons learned for the next government, any other potential pandemics. And there's no need most times for these government members to defend the government, but particularly in light of the WE scandal that we saw, there really isn't any reason to stand and try to protect this government. There's all the reasons why transparency should be even more important today. So again, I'll leave my comments there, Mr. Chair, but I implore the members to reconsider, thinking there's the opportunity in front of you to be able to stand tall and really promote transparency here at this committee, where we can all do that together in a nonpartisan way. But certainly that would begin with withdrawal of this type of motion. Thank you, Mr. Chair.
Thank you, Mr. General. We go now to Mr. Van Bynen. Mr. Van Bynen, please go ahead.
Thank you, Mr. Chair. And I'm supporting the comments that were made earlier by Dr. Jazik. The information we need to be cognizant of, that there is a significant amount of personal information. And the legislation is access to information and privacy. And I think we need to respect the privacy component. This is legislation that's been adopted by the House, and it's been adopted for a reason. And some of the materials that could be involved would be discussions with other orders of government, and it's likely to be caught up. And it's important that they need to be consulted with as we go forward. And so I think there's some degree of privacy in the discussions between different levels of government, and some degrees of privacy for personal information. And again, I want to emphasize that this legislation was put into place to protect people's right to privacy. And the format and the judgment that's being exercised will be exercised in accordance with the rules. Why is it that we would object to exercising and living by the rules that the government has established? Why do we have an access to information and privacy legislation when we don't intend to respect it? There's a real need to respect what's been adopted by this government. And so I will be supporting Ms. Sidhu's motion.
Thank you, Mr. Van Bynen. We go now to Ms. Jansen. Please go ahead.
Yes, thank you. I think I'm a bit mind-boggled by the constant talk about privacy. When we need to understand, Canadians are scared. Canadians are looking to their public officials for good leadership based on good science. Well, how can we get the good science if we're going to be told that there's a lot of privacy that has to be upheld? I mean, if someone's made a mistake, we definitely need to know. And how are we going to know if we're all of a sudden talking, privacy being more important? If there's information, we need to put it on the table so that, for instance, if Canadians aren't wearing masks because, and they aren't, let's face it, when you go out into town, they're not wearing masks. We need to understand what was the information that she got. Lay it all out on the table so Canadians can really see why suddenly now masks work. It's so important. And to suggest that privacy is suddenly of top priority, Canadians are scared and Canadians aren't wearing masks. Privacy needs to take a second place right now, and we need to look at the numbers. If we actually want people to consider her new advice, we are going to have to lay out the information so that nothing is hidden. It's very important. And I think that if we're going to look at this from a nonpartisan perspective, Canadians will respect what this committee is doing. If we can't lay the information out on the line, Canadians are going to continue to not wear masks and do what they're being asked to do, which will, as we know, have its regular effect, which is we're going to have more people get sick. So I'm begging you, we need to make sure we have all the information. We are completely transparent with Canadians. Otherwise, this looks just like some kind of political theater yet again, and Canadians' lives are on the line.
Thank you, Ms. Jansen. Mr. Fisher, go ahead.
Thank you, Mr. Chair, and Matt talked about this committee working very well together, and he's right. This committee has worked well together. In fact, I think if you look back on most of the motions that have come up through this committee, they've almost been, for the most part, unanimous. But we also have for the first time ever, a really good relationship between the provinces, the territories, and the federal government because of the importance of this pandemic and the importance of working together. And I'm quite proud of the way the provinces, territories, and the federal government have worked. Just like within the House of Commons, I'm quite proud of the fact that the opposition parties and the government have all worked well together, and parties have come up with great suggestions, and government has enacted those great suggestions. So I don't want to see that interfere with what we're talking about here today. The thing we want to make sure is that we get all of the information that we are seeking as a committee, but that we also protect the privacy of Canadians. That's what's important. And MP Kwan said it very, very well. Let's think of, and I mean, I can't even imagine the examples, but let's think about someone in Quebec, being part of a briefing note or being part of documentation and being named. That person does not deserve to have their name. Matt's right about public figures. Public figures sign up for this stuff. A lot of people don't sign up for this stuff. I just think that if you've got the ability to provide the level of privacy that Canadians deserve and expect from government, that we should put this language in there to ensure. Again, going back to MP Kwan's points, making sure that this is done in the proper way so that it protects the privacy of Canadians is the outcome that we want. But coming up with, as Ms. Jensen said, coming up with all of the information that answers all the questions of the people in this committee. So I will continue. I've not heard any reason yet to not support Ms. Sidhu's amendment to ensure privacy of Canadians.
Thank you, Mr. Fisher. We go now to Dr. Jaczek. Please go ahead.
Thank you, Chair. I've been looking at this wording very, very carefully in terms of what Ms. Sidhu has presented as an amendment. And I just don't understand where the fear is coming from that we will not get good information. Essentially, we're asking the department to do its assessment and vetting in gathering and releasing the documents as it would be done through the access to information process. That is a process that has been approved. It has almost become sort of standard language. It obviously does protect individuals in terms of their personal information. Many people are very concerned about the privacy of their personal information, but it in no way does it preclude the gathering of important information that we all would like to get through the gist of this motion. It simply puts a layer of protection. Dr. Kitchen, on his motion that we all passed June 15th, had the exact same language in it. And we have yet to see the results of that particular motion as the date was amended. But I just fail to understand how we're going to be denied the type of important information, substantive information that led to decision making by ensuring that personal privacy is protected. Thank you, Chair.
Thank you, Doctor. I'll go now to Ms. Sidhu. Ms. Sidhu, go ahead, please.
Thank you, Mr. Chair. Mr. Chair, I just want to remind all members, we are here to talk about what we not try to score political points. We are here to help Canadians. And as in February, the same language we used, and we respect the privacy for Canadians as well. Just keep in mind, I think my motion is absolutely what we want from them. The main source is what we want, like information. So that information, we should focus on that. So over here, again, I want to remind, this is a 33rd meeting, we work together. Let's focus on Canadians, not on the scoring the political points. Thank you.
Thank you, Ms. Sidhu. Mr. General, please go ahead.
Thank you, Mr. Chair. To address a few points that were raised in terms of why we think this particular language will withhold information, is all I have to do is simply point back to the motion that was adopted at the February 26th, 2020 Health Standing Committee on Health, where we indicated at the time wanting text messages, emails. The government was really nervous about the text messages piece, but then it was sent to the parliamentary council and law clerk's office. During their review of that information, they essentially determined that it's not the government's role the time to redact information. That comes to the committee, and the committee is then determines whether or not to make that information public. I'll read just a quick excerpt from that letter, which was sent to the clerk of the committee at the time, Mr. Jacques, where it says, "We reminded the government officials that the House and its committee's power to order the production of records is absolute and unfettered, as it constitutes a constitutional parliamentary privilege that supersedes statutory obligations. We added that the House and its committees are the appropriate authority to determine whether any reasons for withholding the document should be accepted or not, and that it was for the committee to determine whether it was prepared to accept any proposed measures that would prevent the disclosure of sensitive information for any reason." Essentially saying that these committees supersede the order precedents in terms of the House, and making that this particular motion is a overreach on the ATIP side, and it's something that, quite honestly, this time of day, we want that more information. So I would again request Ms. Sadhu to withdraw her motion based on, this is the non-partisan law clerk and parliamentary council that made that ruling, not a Conservative party or a NDP party or a Bloc Québécois party. So I implore Ms. Sadhu to consider withdrawing her motion.
Thank you, Mr. General. Ms. Kwan, go ahead.
Well, thank you very much, Mr. Chair. I think that perhaps we can find a compromise approach here. Here's what I would like to suggest and points that I would like to make. On the issue around privacy, I think everybody generally are in agreement that privacy issues like names and emails should be protected. And so to that end, I think we should note too that the privacy issues versus that of access to information, the scope is different. The access to information, the scope is far broader than that of privacy. So if maybe we can land on this to say that for privacy purposes, such as names and emails, that we can look to apply the protection of privacy with these documents, and that instead of having the government or the department officials do the vetting of these documents, that it should actually be done through the law clerk's office, so that we can in fact achieve both. And I'm hoping that this could that this could sort of come to an agreement with all of the parties. Previously, HESA has passed motion on February 26, as I understand, that they might be on board to request the law clerk for vetting privacy. So I think that actually achieves what we want to achieve here. So I'd like to see whether or not if Ms. Sadhu would withdraw her motion, her amendment, and then table a different one. I'd be happy to table a different one to have the law clerks do the vetting and for privacy purposes. And lastly, just to refresh everybody's memory, the motion that I talked about on February 26th, I believe it was my colleague, actually, Don Davies, who moved this motion, possibly, that the issue was to have the law clerk vet for privacy, cabinet confidence, and national security. And those were the central themes that were applied to access to information.
Thank you, Ms. Kwan. Just for clarity, I'd like to point out that it's really not up to Ms. Sidhu to withdraw her motion. We have kind of two options. We pass it, we vote on it, or arguably we could do something by unanimous consent. But it's before the committee at this point, and we have to deal with it as it is.
Sorry, Mr. Chair, can I ask a question related to that then? Can there be a amendment to an amendment, or do we have to defeat this and then move another amendment?
There can be a single sub-amendment on the floor for a given amendment.
Okay, can I try this on for size then for a sub-amendment to the amendment that instead of the language where it reads that it will be the department officials who would vet the documents, that it be for the law clerk to vet the documents for privacy, cabinet confidence, and national security? Can we change that? Can that be deemed as one sub-amendment, Mr. Chair?
So you're moving a sub-amendment, that would be in order. So the debate at this point is on the sub-amendment, as Ms. Kwan has proposed. We go now to Ms. Jansen. Do you wish to speak on this sub-amendment, please?
No, I wanted to speak on the previous one. Thank you.
Thank you. Mr. Fisher, would you like to go ahead, please?
I was going to speak on the main one, but I would like to get, just so that I could get this written down in front of me, the wording of the sub-amendment so that I can see how it fits in with the amendment. So I wonder if MP Kwan would reiterate once again. I wasn't fast enough to write it down, but I would like to, I'll keep my hand up for the main motion as well.
Ms. Kwan, if you wouldn't mind. You're muted.
Okay. Yeah, I thought I touched it, but it didn't work. Okay, so my sub-amendment would be, instead of the language where it reads to say that department officials would do the vetting and that the vetting will be done by the law clerk, and the language of the vetting, see cabinet confidence and national security. Uh-oh. Computer here.
So as a point of order, Mr. Chair, then I see Jenny has frozen for a quick second there.
Sorry,
could we get the clerk to give us what that looks like, not you know, in its fullness? Sorry, Jenny.
Yep, sorry, my computer glitched though for 1 second. I think I'm back on now. Yes, yeah, we can have the clerk's office, the clerk to read out the full sub-amendment in its entirety related to the motion. Could we do that? Please, thank you.
Please go ahead, Madam Clerk.
Thank you, Mr. Chair. So this is my understanding of the sub-amendment. So we would delete the words after provided that the, and we would replace it with provided that the Office of the Law Clerk and Parliamentary Counsel vet the documents for matters of cabinet confidence and national security, as well as personal information. The last part there I wasn't sure about.
I think we can use the word privacy.
As well as privacy?
Yeah, privacy
Okay.
pertaining to names and personal information.
Okay, so what I have in its entirety is provided that the Office of the Law Clerk and Parliamentary Counsel vet the documents for matters of cabinet confidence and national security, as well as privacy related to names and personal information.
Thank you, Madam Clerk. Mr. Fisher, does that clarify your question?
It does. I think it gets us to where MP Genero didn't want us. I think it gets us more like the old motion and not quite as good as the wording that we had there using the Access to Information Act. But I will defer to some folks who have been here longer than me, but I think that what we proposed would actually get us to the place that MP Jensen and MP Genero were trying to get to. But I'm just going to continue to think about this. Thank you, Mr. Chair.
Thank you, Mr. Fisher. Ms. Sadhu, please go ahead. Ms. Sadhu, you're muted.
Thank you, Mr. Chair. And I want to echo my colleague Dern. And so if we are going through this amendment, I still prefer ours. So because it protects Canadians' right, and you know, I still want to go on our amendments.
Thank you, Ms. Sadhu. We go to Mr. Kellaway now.
Thanks, Mr. Chair. Actually, I was going on two trains of thought here. I was listening to obviously what Darren was talking about the original amendment, perhaps kind of, I guess, positioning where I thought my original points would be. But to go back to MP Kwan for just a second here, I'd like to kind of build on what she was talking about, but in any event, I think I'll leave it at that. I think I need some time to think about the to Darren's point of thinking about the original amendment as opposed to the sub amendment and what its original intent was.
Thank you, Mr. Kellaway. We go to Dr. Jaksic, please.
Thank you, Chair. And I'd like to thank MP Kwan for introducing what we're saying is a sub-amendment, because I think her concerns around personal information and privacy are very much similar to my own. The only thing is, I don't feel it's really a sub-amendment. It's really a different amendment. So I'm wondering if we couldn't, though I believe you have ruled it that, but in a sense, it changes the Ms. Sadhu's amendment to the extent that I would have thought it preferable if we could vote on Ms. Sadhu's and then perhaps see if Ms. Kwan would like to introduce her sub-amendment as an amendment. It's just getting to be a little puzzling how this is shaping up. So I just offer that because just like Mr. Kellaway, I'm getting a little confused as to exactly what we're voting on.
Ms. Kwan's sub-amendment is on the table, and it is the one we're dealing with. We need to deal with that before we get to the previous, the original amendment, such as it may or may not be amended by this motion. So the debate on the sub-amendment continues. Ms. Kwan, please go ahead.
Thanks very much, Mr. Chair. Just to wrap up my comments, I think that my sub-amendment is one that I think bridges the sides. The amendment that was moved by Ms. Sadhu is much broader in its scope, which raises the concern that much important information may be redacted, and then the seeking of these documents would then become meaningless. This is a process to which the committee had embarked on before, and the documents that came back were effectively meaningless because much of the information were redacted. If the concern truly is to ensure that people's privacy are dealt with, then we can actually, in fact, do that with my sub-amendment to ensure that privacy issues are protected, and so that is to say people's names and personal information would be redacted from the documents. To the other point, previously on February 26th, this committee, the Health Committee, did in fact pass such a motion on a different matter requesting documents and briefing notes and so on, and that the law clerk and parliamentary counsel of the House of Commons were in fact the office in which undertaken the work to vet the documents for these three reasons: privacy, cabinet confidence, and national security. And so I'm really hoping that my sub-amendment would get support so that we can move on to dealing with the many other issues that's before us today at committee.
Thank you, Ms. Kwan. Mr. Fisher, go ahead.
Thank you, Mr. Chair. I think Ms. Kwan's argument there is exactly why I think we want to use our language, because the language that was very close to what is in the sub-amendment is what perhaps caused a lot of the redactions the last time. I totally appreciate what you're trying to get at, MP Kwan. I still think ours allows for more information that the committee is seeking to come back. So, Mr. Chair, I'm not sure exactly how we proceed on this. I guess we have to
we proceed until there's no more debate, and then we will vote.
Okay, so can we go back to a question then that Ms. Jacek, Dr. Jacek asked? This seems to be significantly different, not just a tweak. And you did rule that it could be a sub-amendment, but it seems like it's significantly different than what was proposed by Ms. Sidhu. I don't think, and I'm not certainly by no means second guessing your decision, Mr. Chair. I do think that this takes us in a different direction. So I'm wondering how we proceed here. If in fact, is there a way of finding out if this sub-amendment does represent the integrity of Ms. Sidhu's amendment?
I don't believe there's a requirement that it does, but I will ask the clerk to, if she wishes to give us an opinion. Madam Clerk, would you like to advise here?
Thank you, Mr. Chair. My understanding of this sub-amendment would be that it narrows the scope of what Ms. Sidhu was asking for, and it clarifies or modifies the proposed amendment. So in this case, my understanding of this sub-amendment would be that the documents would arrive from the government unredacted, and that the OLCPC would be in charge of redacting the documents in the manner proposed in the sub-amendment.
Thank you, Madam Clerk. Ms. Kwan, please go ahead.
Thank you very much, Mr. Chair. I just want to put this on the record, addressing Mr. MP Fisher's point of view, to say that the documents that were over-redacted that came back, this is the reality. The law clerk's office never got a chance to do the redaction. In fact, the information they got was already redacted. And given that they did not have a chance to see the original unredacted documents, they were unable to provide the information. That's why it was over-redacted, exactly to the point that Mr. Fisher is raising, MP Fisher is raising, that this motion before us, I believe, will result in a situation where the information that the committee is seeking would be over-redacted. Let me just put this on the public record of what the law clerk's office had provided related to this issue. The government actually didn't allow the law clerk to do the redaction in response to the February 26 motion. That is why it's over-redacted, so I want to be clear about that. And in that letter from the law clerk's office on this subject, they said, quote, Upon reception of the documents on March 15th, 2020, you provided them to my office so that we could make the necessary redactions to protect the privacy of Canadian citizens, permanent residents, and public servants as contemplated by the production order. However, as mentioned above, the documents had already been redacted by the respective departments. As my office has not been given the opportunity to see the unredacted information, we are unable to confirm or adopt those redactions. My office did make one additional redaction to the documents regarding a public servant. At a meeting with my office on March 10th, 2020, representatives of the departments had expressed concerns about providing the committee or to my office unredacted information that would, in their view, fall under statutory disclosure exemptions. During that meeting, we reminded the government officials that the House's and its committee's powers to order the production of records is absolute and unfettered, as it constitutes a constitutional parliamentary privilege that supersedes statutory obligations. We add that the House and its committees are the appropriate authority to determine whether any reasons for withholding the documents should be accepted or not, and that it was for the committee to determine whether it was prepared to accept any proposed measures that would prevent the disclosure of sensitive information for any reason. One such measure was the committee's decision to have my office make the necessary redactions to protect personal information. In the circumstances, it is for the committee to determine whether it is satisfied with the documents as redacted by the departments. My office is at the disposal of the committee should it wish to be provided with more information or require further assistance on this matter. From this quote from the clerk's office, the law clerk's office, is clear that they never actually had access to the original documents to make a determination whether or not the information redacted or what information should be redacted. If MP Fisher has already indicated his concern stands, then he would want to accept my amendment as proposed and let the clerk's office do this work and not the department officials. That's, I think, how we can prevent over-redaction. The over-redaction came from the department, and that's what happened last time. If we're going to learn from that, then I think we can try a different route, which, by the way, what was proposed on February 24th, accepted by the committee. So I would, and then to the point to say that this is somehow a different amendment, I don't think so. I think this is a sub-amendment to go through the redaction process or the access of the vetting process, if you will, Mr. Chair.
Thank you, Ms. Kwan. Mr. Van Bynen, go ahead.
Thank you, Mr. Chair. I mean, the language that we're using relates to the access to information and privacy. Those are principles and processes that have been adopted by the government. Those are principles and processes that would apply to all parties, be it Conservative, NDP, be it the Liberal government. And so I just don't understand why people are reluctant to apply the principles that this government has established as appropriate. A, to provide the information that is necessary and relevant, and B, to protect the privacy of individuals. So what I'm looking at here is that materials that do not contain either the privacy or issues that are raised by other orders of government can be publicly shared as it is requested. But we need to be mindful of the privacy issues. And again, why is it that people are turning their backs to the processes that have been established? Why is it that people don't think that the access to information and privacy regulations are insufficient? Isn't that really what we're looking for? Isn't that what's been established? So what is it? I simply don't understand. I simply don't understand why we're ignoring something that has clearly been established to benefit the Canadian people, to benefit committees, to benefit the government, and to benefit all parties. So why aren't we applying this on a consistent basis for everyone in government? Thank you, Mr. Chair.
Thank you, Mr. Van Bynen. We go now to Mr. Fisher. Go ahead, please.
Thank you, Mr. Chair. I'm wondering about the vetting process and whether a public servant can take the documents and vet them. Just thinking about the legal ramifications. In Ms. Kwan, you took out the access to information process, which is what Parliament uses to vet documents. Did you take that out on purpose because you liked the other possibility more?
Given that was a direct question of you, Ms. Kwan, I will invite you to respond if you wish.
Well, thank you very much. I'm not quite sure what the point is from MP Fisher. I think the point from my perspective is this. We're talking about who should be doing the vetting of the documents. I think that there is a office that can be set up to do it outside of the department. And perhaps then in terms of ensuring that the documents are vetted in such a way without in a nonpartisan way, without any undue influence of any sort or the perception of it, then the Office of the Law Clerk and Parliamentary Counsel of the House of Commons is well suited for this. That is the purpose here. I will remind the committee members that on February 26th, in fact, the language using the law clerk and parliamentary counsel of the House to do this work was in fact adopted by this committee. So this is what I'm proposing to go forward with, and it's already been admitted by MP Fisher that the last set of documents that came back was overly redacted. We already know that, we already acknowledge that. So I think that it would be important to go through this different process. The other thing is somehow to suggest that going through the law clerk's office or parliamentary counsel and the parliamentary counsel of the House of Commons would be deficient. I actually, with all due respect, disagree with any such suggestions. In fact, I would argue that they are well placed to do this work, and in fact can address the concerns of privacy protection. Having them do the work does not eliminate the privacy protection as been suggested by a member. It does not eliminate that at all, but at the same time, it can ensure that the information that I think the committee is seeking can be made available with the privacy protections intact, and to ensure that the public, I think, gets the necessary information about what's happened with respect to this issue around masking.
Thank you, Ms. Kwan. We'll go to Dr. Jaczek now, please.
Yes, thank you, Chair. Well, to follow up a little bit on what Mr. Fisher was saying, this language was used in February. Documents, according to some members of the committee, came back excessively redacted. I'm wondering what would be different this time. Departmental officials surely have their rules within the department to apply access to information through an established process. Surely they're not going to send documents that they haven't vetted through that process to the law clerk and the parliamentary counsel. Surely they have their own rules that apply to the information in their possession. So I'm just puzzled to see, would this really result in a different outcome this time?
Thank you, Dr. Jaczek. We go to Mr. Kellaway, please.
Thanks, Mr. Chair. And it may be my small town kind of, I guess, mindset here, but it seems like we've tried what's being proposed here in February and it didn't work. And now we're proposing something in the original amendment that we think will. And I think if it didn't work the first time, why would we expect a different result? The other aspect that I wanted an answer to, or maybe it can either here or at another time, is the legal clerk. Would they have the same training or ability to vet documents as an ATIP official. So that's just a question as well.
Thank you, Mr. Kellaway. Ms. Sadhu, please go ahead.
Thank you, Mr. Chair. As even clerk said, MP Kwan's motion will narrow the information provided. I think my motion is broader. I echo with my colleagues. If the last time it didn't work, why we take the chance again? So we tried this in February, it didn't work. So we should go with what I proposed. Thank you.
Thank you, Ms. Sadhu. Mr. Fisher, please go ahead.
Thank you. Just ask a question of the clerk if I could. Is there the ability to vet cabinet confidence by the law clerk?
Mr. Chair, I'm not sure about that. I wouldn't think so.
I can't imagine that the law clerks would want to determine what is cabinet confidence as well. Have we thought about asking? Is that something that, and I know MP Kwan gave an awful lot of information that I was trying to follow through, but is there something in what you read there, Jenny, that spoke to the fact that the law clerk would do this on behalf of the committee?
Ms. Kwan, I have a note from our clerk that you need to move your mic a little closer to your mouth. Looks fairly close to me, but I'm not sure if you've adjusted it since, but please be aware of that. Thank you. Please feel free to respond to Mr. Fisher's question. Ms. Kwan, you're on mute.
Okay, how's that now?
That's good.
Okay,
Good
thank you very much. On a number of the points that's been made, first off, on the question around why would we go through the same process again when it was already done for February 24th, just so that every single committee member is clear on this point. On the motion that was passed on February 24th, it did not get followed. Why? Because the law clerk's office did not get the unredacted documents to go through to determine what should be redacted. In fact, they got documents from department officials that was already redacted. That's why it was over redacted. They never got to do that work. The motion that was passed on February 26th by the Health Committee was never followed through, which I believe is probably contempt for the committee's work from the government side. And so that's why. So for the committee members who's arguing to say, if the February 26th motion didn't work, why are we embarking on that process? Well, you're arguing exactly on that point, that the motion, the amendment that was moved by MP Sadhu is exactly the process that produced the documents that were useless. So we're embarking on exactly that same process again if we pass that motion, that amendment, instead of my suggested amendment. On the second point, with respect to the issue around the work of the law clerk's office and that of the parliamentary council, the motion on February 26, the language that I used was exactly the language that I adopted from February 26. The committee actually adopted that and accepted it at that point. The only problem is that they never just actually followed through with that work. The government stopped the law clerk's office from doing that work. So I would suggest that we pass my amendment, my sub-amendment, and follow through with that process and see what the end result is going to be. The long passage that I read through, I believe, is a document that's been shared for all the committee members. And so that's what I've read, and this is what they have indicated, that the office would be prepared to assist. I can read the passage again if the committee members would be so inclined. Would you like me to read that message again, Mr. Chair? It's a long paragraph that I quoted from the letter.
use your best judgment.
All right, for clarity then, I will read the passage again so that all the committee members could hear it. So this is a direct quote from the letter from the law clerk's office on this subject. Quote, upon reception of the documents on March 15th, 2020, you provided them to my office so that we could make the necessary redactions to protect the privacy of Canadian citizens, permanent residents, and public servants as contemplated by the production order. However, as mentioned above, the documents had already been redacted by the respective departments. As my office has not been given the opportunity to see the unredacted information, we are not able to confirm or adopt those redactions. My office did make one additional redaction to the documents regarding a public servant. At a meeting with my office on March 10, 2020, representatives of the departments had expressed concerns about providing to the committee or to my office unredacted information that would, in their view, fall under statutory disclosure exemptions. During that meeting, we reminded the government officials that the House's and its committee's powers to order the production of records is absolute and unfettered, as it constitutes a constitutional parliamentary privilege that supersedes statutory obligations. We added that the House and its committees are the appropriate authority to determine whether any reasons for withholding the documents should be accepted or not, and that it was for the committee to determine whether it was prepared to accept any proposed measures that would prevent the disclosure of sensitive information for any reason. One such measure was the committee's decision to have my office make the necessary redactions to protect personal information. In the circumstances, it is for the committee to determine whether it is satisfied with the documents as redacted by the departments. My office is at the disposal of the committee should it wish to be provided with more information or require further assistance on the matter. So this is the entire quote that I read out earlier from a letter from the clerk's office. So again, to summarize this whole point, the process that was followed on February 26th motion was never followed through with the law clerk's office. They received redacted documents already. Because they had not been able to see the original unredacted documents, they could not comment to say whether or not the information redacted is valid. What we do know is this: the information that came from that redacted documents is clear that it was overly redacted. So if we want to get a different outcome, as MP Callaway and others had suggested, then we should not do what we have already done, and that is to have the department vet these documents. If we pass the amendment as proposed by MP Sadu, then we're going through exactly the same process. If we want to get a different outcome for the purposes of accountability and transparency, I would suggest that we go through the law clerk's office. Thank you, Mr. Chair.
Thank you, Ms. Kwan. Mr. Fisher, go ahead.
Thank you, Mr. Chair. I guess I've done as much thinking and talking about this as I possibly can. I still don't believe that law clerks can handle the cabinet confidence portion, maybe not even the national security portion. I don't know. Ms. Kwan has talked about the clerk's office and the law clerk's office. I understand there are probably two different offices. I think I will continue to support MP Sadu's on this. So I guess we vote on the sub-amendment and then we go back if that doesn't go through and we vote on Ms. Sadu's.
Mr. Chair, just a quick point of order on Mr. Fisher's comments. The I believe that the government can actually withhold the cabinet confidence anyways. So it's there's nowhere do I note that this is referencing the cabinet confidence. If I'm mistaken, then that's on me. But I believe it's that's not part of even really this ask. So essentially, his comments are moot when it comes to cabinet confidences.
Thank you, Mr. Generator. We go to Mr. Kellaway now, please.
Just to go back to it, and it's probably this is a question for the clerk or my fellow parliamentarians who've been here longer than I. But does the law clerk have the security clearance to view the original document, or is security clearance not a factor in this?
I believe that would be a question perhaps for the clerk. Madam Clerk, if you are able, would you respond?
Mr. Chair, I don't have a definitive response for what the law clerk's security clearance is at this time. I would imagine that it's quite high.
Okay. Thank you. Is there any further debate? Seeing none, we will call a vote on the Ms. Kwan's sub-amendment. Madam Clerk, if you would please conduct the vote.
Thank you, Mr. Chair. Those in favor say yay. Those opposed say nay. Mr. Fisher.
Nay on the sub-amendment.
Correct. Mr. Kellaway.
Mr. Kellaway, you're muted.
Oh, nay.
Thank you. Ms. Jacek.
Nay.
Ms. Sidhu.
No.
Mr. Van Bynen.
No.
Ms. Jansen.
Yay.
Mr. Generu.
Yay.
Mr. Kitchen.
Yay.
Mr. Weber.
Yes.
Monsieur Desilets.
Mr. Desilets. Yay.
Yay.
Mr. Chair, the result is 6 yays and 5 nays.
Thank you, Madam Clerk. The amendment passes. So we are now on the motion as amended by the date, the emails changed and further amended now to enable vetting by the, according to language suggested by proposed by Ms. Kwan. Is there any further debate on this? So the debate is now on the amendment, now on the floor. Seeing no debate, I will. Oh, we see Mr. Kellaway. Mr. Kellaway, please go ahead.
Hey, for one moment. I'm having some difficulties here in my office with the technology, so apologize for that. I'd like to make an amendment to the date, but I'm not sure that's what you're asking.
No, we're not at that point yet. We're voting on the amendment that is now on the floor.
Okay, thanks.
Mr. Fisher, please go ahead.
You tell me again. Sorry, we just voted for the committee voted for the sub-amendment.
So the amendment to the motion, as previously amended, the amendment is that the vetting process be now done according to the language proposed by Ms. Kwan. That is the sub-amendment. Sorry, that is the amendment now before this committee, and that is the amendment that we're now debating and eventually we'll vote on. Any further debate on this? Dr. Jacek, please go ahead.
I'm sorry, Mr. Chair, I'm really confused. Could we read what we are debating now, please?
Yes, Madam Clerk, if you would please.
Thank you, Mr. Chair. You're currently debating the amendment, which reads, provided that the Office of the Law Clerk
Oh,
and Parliamentary Counsel vet the documents for matters of cabinet confidence and national security, as well as privacy related to names and personal information.
Correct.
this is a
Thank
quick
you.
point of order, Mr. Chair. What did we just vote on then? That's what I voted on.
We voted on a sub-amendment that changed the Ms. Sadhu's amendment to what you just heard. Okay. So, Mr. Van Bynen, please go ahead.
Thank you. And I would like to get some clarification. I know that the intent here was to gain the benefit and to respect the rights of all people with respect to the ATIP legislation. So can somebody tell me how this alters the process from the ATIP legislation and what that process is? Who would be undertaking that review, and how is what's being proposed any different than simply relying on the ATIP legislation? So is there someone that could give me that advice?
I'm seeing no one's hand go up. Mr. Fisher's hand is up already. I believe you wish to speak on this.
That was a leftover. Sorry.
Okay, no worries.
Mhm.
So the ATIP language is no longer on the table. What we are voting on is the amendment to vet the documents according to the language proposed by Ms. Kwan, which is to have the law clerk do the redactions as necessary. Is there any further debate? Seeing none, the motion, the vote, we will conduct a vote. The vote is on the amendment, and I would ask the Madam Clerk to please conduct the vote.
Thank you, Mr. Chair. All those in favor say yay. All those opposed say nay. As mentioned, this is the vote on the amendment. Mr. Fisher,
Nay.
Mr. Kellaway,
Nay.
Ms. Jacek,
Nay.
Ms. Sidhu,
Nay.
Mr. Van Bynen,
Nay.
Ms. Jansen,
Yay.
Mr. Generu,
Yay.
Mr. Kitchen,
Yes.
Mr. Weber. Oh, Mr. Weber, I did not hear you.
Yeah, no, I had it on mute. Yes.
Thank you. Monsieur Desilets,
Mr. Desilets? Yes.
Ms. Kwan.
Yes.
Mr. Chair, that is 6 yeas and 5 nays.
Thank you, Madam Clerk. So the amendment carries. So we are now on the main motion, Mr. Generu's motion, as twice amended now. Is there any further? Okay, I see Mr. Kellaway. Mr. Kellaway, you have your hand up. Please go ahead.
Yes, I talked about it before in terms of the original amendment, looking at the 2 dates in question, the August 3rd and the August 10th dates in the original motion. And given that August and summer is going by so quickly, is just around the corner, I certainly like to make a friendly amendment in terms of the dates being changed respectively to August 31st and August 31st.
Is that an amendment?
That would be an amendment to what's on the motion. Yes.
Okay, very well. So we now have an amendment on the table, which is to amend the dates. Could we clarify what the dates are going to again?
Sure. I'll just read it out. The committee send for the following documents to be provided by the government by Monday. The change would be August 31st, 2020, and the documents be published publicly on the committee's website by Monday, August 31st, 2020.
Thank you, Mr. Kellaway. We go to Mr. Fisher now, please.
I think that's reasonable. It's that, a lot of our wonderful public servants will be hopefully getting a little bit of time off during the summer. I think we can all agree that they've been tasked with Herculean work and effort the last 110 to 115 days. August 3rd is not very far away. I think it's a good compromise to move it up to the 31st of August.
Thank you, Mr. Fisher. Is there any further debate? I see Ms. Sidhu. Ms. Sidhu, please go ahead.
Mr. Chair, I would like to speak in favor of MP Calway's amendment. A notice of this motion was given. This motion removed July 7th. So pushing the date of production of August 31st would provide approximately the same timeline. It's worth nothing that given the most. So people are working from home, locating these documents versus more for a challenge. So I think I'm in favor of Mr. Calway's motion. This is a reasonable ask, as public servants have been working very hard recently due to COVID-19. Thanks.
Thank you, Ms. Sidhu. Is there any further discussion? Mr. Van Bynen, please go ahead.
Thank you, Mr. Chair. We're looking at a considerable amount of documents, and frankly, the amount of time that it has taken us to, and we're not even finished with this motion as yet. I think that staff genuinely want to meet the timelines, and requesting them to meet timelines that are unmanageable, I think, is unfair to them. This is a particularly busy time of year, and as mentioned by Ms. Sidhu, a lot of people are working from home, so it's not just the normal processes. And now that we've added to that additional steps, then I think that the consideration for additional time is quite appropriate, and I will be supporting that amendment.
I have a note from the clerk to please verify the dates. And there's a comment here that to receive the documents, unredacted documents, and to post them on the website the same day doesn't allow time for vetting them. So perhaps you could clarify, Mr. Kellaway, the dates again.
Sure. So given what you just said, I mean, we'd be looking at the first change in date, documents to be provided by the government by Monday, August 31st. And what I'm hearing is that it obviously can't be done during the same day. So I think it's reasonable to look at a week later, September 7th, perhaps.
So would that be unredacted documents by August 31st?
I believe so.
So that's essentially a change to what was moved. Do we have unanimous consent to adopt these changes, or do we need to do a sub amendment? Can I get some indication of whether we are prepared to accept Mr. Kellaway's clarification? Seeing no dissent, we shall deem it that it was moved.
Mr. Chair, sorry, I believe that I have my hand up.
Oh, sorry, I apologize. Go ahead.
Yeah, no, I just wanted to I guess I was going to offer it being a friendly amendment. I'm not sure if you've ruled those out of order before, but certainly willing to accept Mr. Kellaway's friendly amendment if so chooses.
Thank you, Mr. General. As a matter of process, there is no such thing as a friendly amendment, but if we can agree to do things unanimously, we can do all manner of wonderful things. So I am seeing no dissent to Mr. Kellaway's clarification, let's say, and so I will take that as unanimous consent. So I see no further discussion. Is there any more debate? So let's just clarify from the clerk, please, what the amendment is at this point.
Thank you, Mr. Chair. So it is to change the first date to August 31st. That the dates Monday, August 3rd, 2020, and Monday, August 10th, 2020 be replaced by the dates Monday, August 31st, 2020, and Monday, September 7th, 2020, respectively. Also, a quick note that September 7th is in fact Labor Day.
Oh. Would that be unredacted documents by the 31st?
Mr. Chair, the motion does not specify that. Someone would
Okay.
have to make that amendment.
All right.
Okay.
Very well. So the motion as the amendment as before us is to just change the dates.
Sure.
And seeing no further debate, no further discussion, we will have the vote on that amendment. Madam Chair, would you please conduct the vote?
Thank you, Mr. Chair. All those in favor say yay. All those opposed say nay. Mr. Fisher.
Yay on the date change.
Mr. Kellaway.
Yay on the date change.
Ms. Jacek.
Yes.
Ms. Sidhu.
Yay on the date change.
Mr. Van Bynen.
Yes.
Ms. Jansen.
Yay.
Mr. Generer.
Yay.
Mr. Kitchen.
Yes.
Mr. Weber.
Yes.
Monsieur Desilets.
Mr. Desilets, yes.
Ms. Kwan.
Yes.
Mr. Chair, that is 11 in favor.
Thank you, Madam Clerk. So the discussion is now on the motion as amended. Is there any discussion on the motion as amended? Mr. Kellaway, please go ahead.
Sorry about that, Mr. Chair. Again, maybe I'm slow on the uptake. So can you explain to me what we're talking about right now, just in terms of, I have some additional changes that I'd like to make. I just don't want to overshoot.
Of course. Madam Clerk, could you please read the motion as it stands, if you're able? So basically, we have Mr. Genero's motion that was modified to remove emails, subsequently modified by the motion to add a vetting process as per Ms. Kwan's proposal, and now with the dates changed per Mr. Kellaway's proposal. That is now the motion we are debating and voting on, so, when the time comes. So any further discussion on the motion? Mr. Kellaway, I see your hand is up still.
That's still, it's not coming off, Mr. Chair.
Okay, okay, very well. So seeing no debate, Mr. Kellaway, your hand went up and then back and then away again. So, but seeing no debate at this, no discussion at this point, no hands in the air, we shall call the vote on the motion as amended. Madam Clerk, if you would.
Mr. Speaker, sorry, is this the whole entire amendment? No more amendments can be made to this motion?
If it is the will of the committee to amend it further, they may.
It is.
Okay. Mr. Kellaway.
Sorry, point of order, Mr. Chair, point of order. I think you just called the question, though. Is that not not binding? Do we not move forward then if you call the question?
Well, I think it's important for debate, for the proper dealing with these matters, that everyone has a chance to speak appropriately. And with certain confusion on the floor, I think I was looking for people to put their hands up, and there was a delay. So I'm going to allow the debate to continue. Mr. Kellaway, please go ahead.
Sure, and thanks for that. And that's what I was looking to do. So perhaps the confusion was on my part. But looking at the original motion, looking to have removed from the motion the references to the Minister of Health's office and the Prime Minister's office, respectively.
Okay, would you please clarify your amendment, please?
Sure. So do you want me to read? read it?
Yes, please.
Okay. So we could look at all documents, briefing notes, and I believe it's memorandums regarding the emergency evidence that altered the government's advice on wearing masks referenced by Dr. Tam, Chief Public Health Officer, at her appearance before the Standing Committee on Health on Tuesday, May 19th, 2020, including documents, briefing notes, to and from, between Health Canada, the Public Health Agency of Canada, looking to strike the Minister of Health's office and the Prime Minister's office.
Thank you, Mr. Kellaway. So the amendment on the table at the moment is to strike from the motion as amended, to strike the Minister of Health office and the PMO's office. I see Ms. Sadu. Ms. Sadu, please go ahead.
Mr. Chair, just a point of order again. Wanted to at least allow Mr. Kellaway the opportunity to try to explain himself, but he's essentially presented another amendment, and you did call the question. So, you know, if you're prepared to go back on your own word this time, you know, I think that calls the question the chair. Quite frankly, if you've called this question, we're about to vote on the question, and then suddenly you allow another amendment from yet again another government member who was slow in the response on certain things. So I think you know, this is ruled completely out of order, and the vote's been called on this motion, and we should be proceeding to that vote, not looking for other amendments at this point in time that would appeal to the government members.
Yeah, point of order there, Mr. Chair. I think it was clearly evident I was trying to get my my points across, and there was some confusion there.
Thank you, Mr. General and Mr. Kellaway, on your points of order. The objective here is to have these matters fully and frankly debated. I was looking for indications of interest in discussing, and there was a delay on Mr. Kellaway's part. We had not actually began the vote, so I'm going to rule it as in order to carry on the debate.
Also, as a point of order, Mr. Chair, sorry to interrupt, Mr. Kellaway said, is it appropriate at this time that I have another amendment? And you said we were still on the previous thing, so he held back.
Yeah.
Mr. Chair, this meeting's been ongoing for 2.5 hours. I think he's had ample time to debate his particular amendment. So that logic I don't see. In terms of Mr. Kellaway perhaps dropped the ball and wasn't able to bring his motion forward, but that's the way things go. There's 3 other motions. Well, I welcome him to bring forward some other.
So we're getting into debate on point
of order. I assure you, no balls were dropped, and I think
let's all maintain some decorum here. We're not going to debate the point of order. The ruling has been made. We are now debating the amendment as proposed by Mr. Kellaway. And Ms. Sadu, you have the floor.
Thank you, Mr. Chair. I support Mr. Kellaway's motion. Why? Because we are finding from other committees that is essential we narrow the scope to what we are trying to get at.
Chair,
that is why I'm supporting this amendment, because it will help to narrow the
point of
scope.
order, Mr. I'm not.
Pardon me, Mr. Van
I'm not hearing very well here. There's a lot of static on what I'm hearing. Is anybody else hearing that static? Because it's not coming through very clearly here for me.
I'm hearing that your audio feed is broken up. I suspect there's a problem on your end. I would suggest perhaps to deny us your vision, your face, and maybe try it without video, and see if it works better. That will cut down the bandwidth a little bit. So I'm sorry, Ms. Sadu, please go ahead.
Thank you, Mr.
Ms. Sadu, you're on mute.
Okay. Thank you, Mr. Chair. I support Mr. Kellaway's motion. Why? Because we are finding from other committees that it is essential we narrow the scope, what we are trying to get at. And I think with this motion, we are aiming that, and I think it's a good amendment. That is why I'm supporting that.
Thank you, Ms. Sadhu. We go down to Mr. Fisher. Please go ahead.
Thank you, Mr. Chair. And I think when you've got, a memo going from one place to another, having that memo and having that memo are exactly the same. I think this is just a little bit of redundancy. You've got your public health agency in there. You've got all the other groups in there. I think it makes sense. You don't necessarily have to have the to and the from.
Thank you, Mr. Fisher. We go now to Ms. Jaczek, Dr. Jaczek.
Thank you, Chair. Yes, I'm also concerned about a lot of duplication. I think the memo is pretty inclusive, including as it does all the documents, briefing notes and memorandums between Health Canada, the Public Health Agency of Canada, and the Privy Council. Between all those three, it's hard to imagine that there would be any further documents that could be of interest from the Ministry of Health or from the Prime Minister's office. I would expect that they would be the duplicates forwarded to them. And I think we're very mindful of the time that is taken by staff in preparing all these documents, taking them away from other tasks that they're responsible for. And I think the memo or the amendment as proposed by Mr. Kellaway is sensible and will result in getting documents that are interesting. We want to obviously see those documents, and I think what we have is quite sufficient. Thank you.
Thank you, Dr. Jaczek. We go now to Ms. Jansen. Ms. Jansen, please go ahead.
I have to say, I'm absolutely gobsmacked at the suggestion that as Health Committee, we decide not to have any documents from the PMO or the Health Minister. If we want to dispel the fear that Canadians have right now on these issues, we need to show them we have turned over every rock to ensure we've done our utmost that we protected them. Any obfuscation on our part of the committee, it just further harms the trust levels that Canadians have in our institutions. I do not understand why we would like to not include the Prime Minister's office and the health minister. It just makes no sense. Gain their trust, open up, be transparent.
Thank you, Ms. Jansen. Mr. Fisher, please go ahead.
Thank you, Mr. Chair. And when you talk about transparency and you talk about opening up, that's what we've done in this committee. We have done that. Every single motion that comes forward, this committee has worked very, very well together to come out with an outcome. So, I take a little bit of offense to, this open up and be transparent thing when there's no lack of transparency here. But to have the to and the from in the same memos and briefing notes, there's no need to have it all and to put these public servants to this level of work and this level of effort to get a carbon copy of what we're getting from another group. And also a lot of these things are going to other committees as well. So I think that it's relatively reasonable to think that we can, we just voted, the Liberal side didn't vote to support MP Kwan's motion, but the rest of you voted to support MP Kwan's motion that narrowed the scope when we were trying to open it up to actually get to where people were wanting us to go. I think what you'll see when things come out is you're going to see that narrow motion is going to get you less than maybe you thought, but I could be wrong. We'll see when that comes forward.
Thank you, Mr. Fisher. We go to Ms. Sadhu.
Thank you, Mr. Chair. That is what we are proposing, is to remove transactional communication between these two offices along with the other minor amendments while maintaining the advice that is prepared by officials. It is priority for government department to respond to these productions order as quickly as possible. That is why I'm supporting that.
Thank you, Ms. Sadhu. Is there any further discussion? Seeing no hands. I see I see Ms. Kwan. Ms. Kwan, please go ahead.
Thank you very much, Mr. Chair. On this amendment, I would argue that it would be important, in fact, to get the documents to the Minister of Health and to the PMO's office. At the end of the day, ultimately, those are the two political masters, if you will, where things are put to them. So I think that we should be accessing that information. And this follows really the government's perspective as well. The Prime Minister back in 2015 actually wrote an open letter which said, quote, government information must be open by default. Simply put, it is time to shine more light on government to make sure it remains focused on the people it was created to serve. Was the quote from the Prime Minister. So I think that is in the spirit of that, and to apply the motion that we're speaking to the Minister of Health as well as the PMO's office. I think in fact, we're in a health committee here. These decisions are in fact ones that are before the Minister of Health and perhaps in some cases before the Prime Minister's office as well. So I would not support the amendment as proposed by MP Callaway.
Thank you, Ms. Kwan. We go now to Mr. Van Bynen. Please go ahead.
Thank you, Mr. Chair. I'm leaning back on my experience as a municipal official, and it gave us the opportunity to look separately at each of those issues. And I think there would be good value, and so I propose a sub-amendment that we delete the PMO's, the Prime Minister's office, in order for us to be able to deal with the question as to whether or not the Minister of Health's office should be included. So during my municipal experience, we divided the question. I don't know what the process is here. And if that requires a sub-amendment, I would certainly propose that sub-amendment. But I think we should consider each one of those offices individually, because each of them have different roles in this.
So, Mr. Van Bynen, are you moving such a sub-amendment?
Yes. So the sub-amendment that I'm moving is that we delete the amendment that, for the time being, the amendment that would include deleting the Minister of Health. So what I'm trying to accomplish is that we first vote on the Minister of that we leave the Minister of Health in there and delete the Prime Minister's office. So I'd like to first deal with deleting the Prime Minister's office, and so that the amendment would only include the Minister of Health.
So just to clarify, if the amendment includes Minister of Health, then what you are doing is removing the Minister of Health from the original amendment, right?
I meant it the other way around. So initially, I'd like the discussion to be around excluding the Prime Minister's office, and then have the discussion around subsequently separately dealing with each one of those offices separately. Now, I don't know how we would do that officially, and perhaps the clerk can be of some help to us. But it seems a straightforward request in that we deal with each one of those offices individually, because people may have different reasons for supporting each one of those, the amendment in that respect.
So Mr. Callaway's amendment was to remove both the PMO and Ministry of Health from Mr. General's motion, and the upshot of your amendment would be to only remove the PMO from this. Okay.
Yeah. I think it's going back to the point that was made by Ms. Kwan, and that is that this is the Health Committee, and so for very different reasons, people might want to consider that separately from the PMO's office. I think that should be a discussion that we should have, and like I say, it's not as familiar with federal protocols, but that's the intent or the upshot of what I'd like to accomplish.
So the stub amendment then is that you're moving to remove from Mr. Callaway's motion amendment the mention of the Minister of Health office, correct?
Right.
Very well. So the sub-amendment is so moved. Is there any discussion on the sub-amendment? Seeing no discussion on the sub-amendment, we will therefore go for a vote on the sub-amendment.
So just please clarify for me, Mr. Chair, what the outcome of voting favor or against this sub-amendment is.
Of course.
I know what the intent. I know what the intent is, but I just want to be sure that that's what's accomplished.
So, Madam Clerk, if you would please clarify for Mr. Van Bynen.
Thank you, Mr. Chair. So if I follow this correctly, then what Mr. Van Bynen is proposing is that the words Prime Minister's Office be considered as a separate amendment. So that would be your sub-amendment in this case. You're further clarifying. So you would vote, if you voted in favor that the words Prime Minister's Office be considered as a separate amendment, then you would deal with the First Amendment, which is the Minister of Health's office. After such a time as you've completed that, you would move then to your separate amendment, which is Prime Minister's Office.
Okay.
Actually, my understanding was different. Mr. Kellaway moved to remove the Prime Minister's Office and the Minister of Health from Mr. Genero's motion, and Mr. Van Bynen, I believe, has just moved to remove from Mr. Kellaway's amendment the mention of the
Prime Minister's Office.
Okay.
I think from the health, you removed the health minister from Mr. Kellaway's office. By doing so, then the motion, the amendment, if that passes, the amendment, Mr. Kellaway's motion as amended would simply remove the Prime Minister's office from the original motion. So are we clear as mud at this point? So Mr. Kellaway, just to clarify one more time, Mr. Kellaway moved to remove from Mr. Genero's motion as amended. He moved to remove the Prime Minister's office and the Ministry of Health. Right. And Mr. Van Bynen's sub-amendment removes from Mr. Kellaway's motion mention of the Minister of Health.
Thank you, Mr. Chair. So I can say that the sub-amendment would be that the words Prime Minister's Office be removed from the sub-amendment. Or sorry, from the amendment, sorry.
I think not. I think that the motion is that that the Prime Minister, the Health Minister's office be removed from Mr. Kellaway's amendment. By doing so, if that amendment passes, if that sub-amendment passes, then Mr. Kellaway's motion would be simply to remove the Prime Minister's office from the original motion. Right.
So that's really the issue, is right. To whether or not we're dealing with the Prime Minister's office. I just want to deal with them separately, Mr. Chair. Like I say, the procedural gymnastics I have yet to develop a better understanding of.
So your motion, Mr. Van Bynen, would, if it passes, would make Mr. Kellaway's motion simply that the Prime Minister's office be removed from the original motion. Okay? Mm-hmm. All right. So I hope we're clear now. Any discussion at this point? Very well. So let us vote then on this Mr. Van Bynen's sub-amendment. Madam Clerk, if you please conduct the vote.
Thank you, Mr. Chair. Mr. Fisher.
Yay to the sub-amendment.
Mr. Kellaway.
Yes to the sub-amendment.
Ms. Jacek.
Yes.
Ms. Sidhu.
Yes to the sub-amendment.
Mr. Van Bynen.
Yes.
Ms. Jansen.
Nay.
Mr. Generu.
No.
Mr. Kitchen.
No.
Mr. Weber.
No.
Monsieur Desilets.
Mr. Desilets, yes.
Juan.
No.
Mr. Chair, that is 6 in favor and 5 opposed.
Thank you, Madam Chair. So Mr. Kellaway's amendment as amended is now that the Prime Minister's office be dropped from the original amendment as previously amended. Is there any discussion on that question? So any discussion on Mr. Kellaway's motion as amended by Mr. Van Bynen? Seeing none, we'll call the question on the Mr. Kellaway's motion as amended. So, Madam Clerk, if you would please conduct the vote.
Thank you, Mr. Chair. Mr. Fisher.
Yay.
Mr. Kellaway.
Yay.
Ms. Jacek.
Yes.
Ms. Sidhu.
Yes.
Mr. Van Bynen.
Yes.
Ms. Jansen.
No.
Mr. Generu.
No.
Mr. Kitchen.
No.
Mr. Weber.
No.
Monsieur Desilets.
Mr. Desilets. Yes.
I'm sorry, Ms. Kwan, I did not hear you.
Yes.
Thank you, Mr. Chair. That is 7 in favor and 4 opposed.
Thank you, Madam Clerk. So, Mr. Kellaway's motion as amended is carried. So the debate now, discussion now goes to Mr. Genero's motion as multiply amended. So is there any further discussion on Mr. Genero's motion as amended? I'll ask one more time. Is there any further discussion on Mr. Genero's motion as amended? And seeing none, I will ask Madam Clerk to, Mr. Fisher, please go ahead.
So can we read the amended motion that we are getting ready to support? Because my understanding is it's now removed the Health Minister's office and the Prime Minister's office.
That's not correct. It is removed the Prime Minister's office only.
Okay.
And the dates were changed according to, I guess, Mr. Kellaway's motion, and the language for vetting, according to Ms. Kwan, has been added. And previously, we removed emails. Do you still require the motion to be read?
Yes, please. I'd like to hear what the motion says. Mine is all scratched up.
Okay. Madam Clerk, if you would please accommodate us. Thank you.
Thank you, Mr. Chair. Pursuant to Standing Order 108-1A, the committee send for the following documents to be provided by the government by Monday, August 31st, 2020, and that the documents be published publicly on the committee's website by Monday, September 7th, 2020. All documents, briefs, notes, and memorandums regarding the emerging evidence that altered the government's advice on the wearing of masks referenced by Dr. Teresa Tam, Chief Public Health Officer, at her appearance before the Standing Committee on Health on Tuesday, May 19th, 2020, including all documents, briefing notes, and memorandums to, from, between Health Canada, the Public Health Agency of Canada, the Minister of Health's office, the Privy Council, and the Privy Council regarding the management of the National Emergency Strategic Stockpile from 2015 to 2020, including supply inventory broken down by number and all updates sent to the government and the Government of Canada's contracts for PPE since January 2020, provided that the Office of the Law Clerk and Parliamentary Counsel vet the documents for matters of cabinet confidence and national security, as well as privacy related to names and personal information.
Sorry, I was on mute. My turn. I apologize. Mr. Kellaway, you have the floor.
So in the spirit of MP Van Biden's amendment, my understanding is then we should move to amend to exclude minnow in a separate amendment, if I'm not mistaken. And I defer to my colleague on that, MP Van Biden.
That's really a matter up to you whether you wish to move a sub-amendment, or sorry, an amendment to the motion as just presented. Do you wish to move that amendment?
Yeah,
I wish to move that amendment. Yes.
Okay, Mr. Kellaway's motion then is to remove. I'm sorry, was it the PMO or was it the Privy Council office?
No, it was the.
It was
Minister of Health.
It was the health minnow.
The health minnow is already removed. Sorry.
Nope.
Sorry, that now I'm getting confused. So the motion, Mr. Kellaway's motion, is to remove the health ministry from Mr. Generous motion.
That's correct.
All right. Thank you. So the discussion now is on Mr. Kellaway's amendment, and I see Ms. Jansen has her hand up. Please go ahead.
So I like to get this straight now. We have now been on this meeting for 2 full hours. We are trying to get clarity and transparency in regards to these issues of mask use and what Dr. Tam knew, what the PMO knew, what the health PHAC was. And we've spent 2 full hours trying to make sure that we don't get information from the health minister and the PMO. It is absolutely mind-boggling. If we want Canadians to trust the process, then we need to make sure that we actually have all the information and nobody gets left out. When we look at where we're at right now with the PMO on a number of other issues that they have tried to keep not transparent, we can see that Canadians have a reason to be concerned about this. And it absolutely blows my mind that we have spent 2 hours trying our very best to make sure the PMO and the health ministry gives us no information. I'm begging you, we need to make sure Canadians know exactly what happened so they will trust the institutions in which they are being asked to follow. I'm begging you.
Thank you, Ms. Jansen. We go down to Dr. Jaksic.
Well, thank you, Chair. And certainly, I think this debate is a very important one, and 2 hours is not enough necessarily to ensure that democracy and all views are being heard. And the previous member who spoke may not necessarily like what the rest of us duly elected representatives are saying, but we have the right to do so. I am going to be supporting MP Kellaway's motion because, as I said before, I do believe that this will simply be a duplication. We have sufficient information, surely, from the very important offices that are included in the motion, namely Health Canada, the Public Health Agency of Canada, and the Privy Council. And so, not to belabor the point, but I feel strongly that each of us should have every opportunity to speak to each one of these sub-amendments, amendments, and the motion itself.
Thank you, Dr. Jaksic. Mr. Fisher, please go ahead.
Thank you, Mr. Chair. The motion asks for all the emerging evidence that altered the government's advice on the wearing of masks referenced by Dr. Theresa Tam. You're going to get that. You're going to get that from the Chief Public Health Officer. You're going to get that from the Public Health Agency of Canada. You're going to get that from Health Canada. You're going to get that from the Privy Council. Again, a lot of the rest of it will be redundancy. The emerging evidence, the science, which has directed COVID-19 since the start, the fact that we've said at this committee before, politics did not enter into the response for COVID-19 in Canada. Probably the reason why we've done so well in this pandemic is the fact that we've used science to provide outcomes on how we proceed each and every day, and we've not allowed politics to get involved in this. So that's what you're looking for. That's what the committee's looking for. emerging evidence that altered the government's advice on the wearing of masks referenced by Dr. Teresa Tam, the Chief Public Health Officer, at her appearance at the committee on May 19th, 2020. That's exactly what this motion will bring us.
Thank you, Mr. Fisher. Ms. Kwan, over to you.
Thank you very much, Mr. Chair. I think precisely as members are arguing that we want to make sure that the confidence of the public is reassured, that decisions are made in a nonpartisan way, that the public health officials' information and advice to the ministers on up are consistent. And precisely for those reasons, I think if nothing else, for us to receive this information from the Minister of Health, and I would argue the PMO's office, although that motion, that amendment didn't pass, I would argue that in the very minimum, we should be getting this information from the Minister's Health office. If nothing else, all that it would do is to reassure the public that in fact the decisions are made and information's been shared to the Minister of Health, is made available to the public for all to see. So I think that in the spirit of transparency and accountability, that this amendment not be passed. I think it is absolutely critical for the committee to access this information, and I think it's critical for the public to access this information. So I would really urge the committee members who's been thinking about excluding this information from being obtained from the Minister of Health's office to reconsider that. The other point I want to make is this: it's been repeated over and over again by government MPs to say that somehow this will be duplication of information, as though somehow they already know. Well, I don't know at this point in time. We don't know at this point in time. So let's be sure that we go through the process here. We're going to do this work anyway. The officials are doing this work anyway. Let's just be sure and clear the air, and that that information is shared for the committee members and for the public for transparency and accountability.
Thank you, Ms. Kwan. We go now to Ms. Jansen.
I think it's incorrect when Mr. Fisher says that we did really well. We did mediocre. And since we did mediocre, we need to be able to show Canadians why we didn't get a better outcome like other nations did. I had many seniors die in a seniors home close to my home. We need answers. Let's show the redundancy. I'm happy to show redundancy. Canadians need to know why things happened. And the only way we're going to do that is if we actually turn over the rocks. And that's from all levels of government. And the suggestion that we've done well, because we have to think about the fact that provinces actually did their own thing because they didn't probably have confidence, I'm guessing, in some of the things that were coming out of the federal government. Let's look at it. Let's see so we can actually help Canadians know that we can be trusted, that we make good decisions based on good science. Let's not cover stuff up or even have the appearance of covering stuff up.
Thank you, Ms. Jansen. I'll go to Ms. Sidhu, please. Go ahead.
Thank you, Mr. Chair. I just want to let members know the important information is being included in the documents. Again, I just want to say that we are here, even though Ms. Jansen said it's 2 hours, even though 2 hours is less when we are working for Canadians. Again, I am saying that it's the 33rd meetings. We are working hard, even though before that, even though we voted yes for, we work together. So let's work together now, and you are getting what you want. If we are excluding the health minister's office, again, we are duplicating that, and what the information we want, we all can get it. Thank you.
Thank you, Ms. Sidhu. Mr. Van Bynen, please go ahead.
Thank you, Mr. Chair. I couldn't agree more with Mr. Fisher. The information that we're looking for will precisely be provided by the Public Health Agency. And I don't think that we're helping ourselves, and I don't think that our credibility is going to be improved by taking a scattergun approach and shooting at everybody in terms of anyone who might have information. Let's decide on what it is we're trying to understand. Now, this motion, as I understand it, is dealing with two things and two things only: the wearing of masks and the national emergency stockpile. So why is it that we're turning over rocks, so to say, everywhere else on the Parliament Hill? To me, I think we should be focused on the question. And the question is about, again, the emerging evidence that altered the government's advice on wearing masks, as referenced by Dr. Tam, and the National Emergency Strategic Stockpile from 2015 to 2020, including supply inventory. So why don't we focus on those things and make sure that the information that we're seeking specifically comes to us and addresses that from the people who are most knowledgeable of all that. I think that there's enough on the hands of the government and the people who are delivering the health care that we need now. This situation isn't over yet. And I think we should focus on the issue and the question. And that's really what I think we should be doing. And to me, the information that we're seeking for can be achieved without involving all of the other groups of the government. And as I say, a scattergun approach is not helpful, and it confuses the issue, and it undermines people's confidence because we're looking for something that we don't know what we're looking for. Why don't we focus on the areas where the information is available? Why don't we focus on the people who are providing that information? So I will be supporting the motion.
Thank you, Mr. Van Bynen. Dr. Kitchen, please go ahead.
Thank you, Mr. Chair. And, you know, we hear a lot of talk about science, and science is multifactorial, and information is provided by multiple scientists around the world. And the Public Health Agency has received information, and the Health Minister has received information. And ultimately, the Health Minister has received that information from multiple facets, not just the Public Health Agency of Canada. One would assume that the Minister has received information from the provinces and their scientists and the great work that their public health doctors have been doing. So for us to turn around and say that purely we're going to get the answers that we want, or because of this is what we're asking for, is not there. We need to hear all the science. We need to know the information. Canadians need to know the conversations that the Health Minister and her office did, besides just listening to the Public Health Agency of Canada. We have heard from multiple people throughout this committee of how the communication has been broken down, that it never got out and put out by the doctors and the scientists. So for us to turn around and say we're not going to hear from the Health Minister, it is to me demeaning to Canadians. And I think we need to listen to that and hear that information. So I will be voting against this.
Thank you, Dr. Kitchen. And Ms. Jansen, please go ahead.
Again, I think it's very, very important that we let Canadians know that we have done our utmost to ensure all the information is out there. And I am willing to be here 4 hours, 8 hours, 12 hours, you name it. I'm here. I'm very concerned about my constituents. What I think is very, very important is that all the information comes out. With their last health meeting, we had witnesses suggest that there was no reason, no new science for Dr. Tam to use to switch. She flip-flopped, and the suggestion was made that she flip-flopped because we did not have enough personal protective gear. We need to make sure that there was no interference politically at all. And how are we going to do that? We're only going to do that by providing all the information from all the different actors. And to suggest that scattergun is ridiculous.
Well, thank you, Ms. Jansen. Is there any further discussion on this amendment? Is there any further discussion on this amendment? Seeing none, we will call a question. Madam Clerk, if you would please conduct the vote.
Est-ce qu'on peut quand même juste relayer?
Excuse me. Could we read again? Madam Clerk, could you please read the amendment?
Clerk, if you wouldn't mind.
Thank you, Mr. Chair. The amendment is that the words Minister of Health's office be removed from the motion.
Is that clarified for you, Monsieur Desilets?
Oui, tout à fait.
Yeah, that's what I understood. Thank you very much.
Thank you. Madam Clerk, please go ahead with the vote.
Thank you. Mr. Fisher,
Yay.
Mr. Kellaway,
Yay.
Ms. Jacek,
Yes.
Ms. Sidhu,
Yay.
Mr. Van Bynen,
Yes.
Ms. Jansen,
No.
Mr. Generu,
No.
Mr. Kitchen,
No.
Mr. Weber,
No.
Monsieur Desilets,
Mr. Desilets? No.
Ms. Kwan.
No.
Thank you, Mr. Chair. That is 5 in favor and 6 against.
Thank you, Madam Chair. So the amendment is defeated. We go now to Mr. Genero's motion as previously amended. So the discussion is now on Mr. Genero's motion as previously amended. Mr. Fisher, I see your hand up.
Thank you, Mr. Chair, and all these amendments. I'd like to move my own amendment. I would like to change the date of 2015 to 2010 in the middle of the motion where it says, regarding the management of the National Emergency Strategic Stockpile from 2015 to 2020, including supply inventory broken down by number and all updates sent to the government. The reason I do so is because we tragically saw when we came to government that we had a stockpile that had been essentially expired equipment, and the previous government somehow allowed that equipment to sit there and not rotate it. And of course, we heard a lot of feedback from members of this committee about how atrocious that was, that this government inherited a very out of date and expired stockpile. So I would suggest if we move back to 2010, we could get some perhaps information and data as to why that sat there gathering dust in our strategic stockpile.
Thank you, Mr. Fisher. So your amendment, you are amending the motion to reference 2010 instead of 2015. Is that correct?
Yes, where it speaks specifically to the management of the National Emergency Strategic Stockpile, not in the other parts of the motion.
Okay, thank you. So the debate now is on the Mr. Fisher's amendment. Mr. General, please go ahead.
Thank you, Mr. Chair. In the of transparency, certainly, don't agree with the members' assessment of poorly managed in the past. This government has had 5 years to essentially do something about what was ever put forward. But at the very beginning of this committee, I preached that it was important for all members to look at where we're going forward, and if certain things that had happened, we want to make sure that we correct that in the future for future generations and any other potential pandemic. So I'll certainly be supporting that motion. If he'd like to go back as far as 2000, I'd be happy to support that particular motion. However, if the motion on the table, again, I think in the spirit of transparency, I think it's important for Canadians that we see that the changes that have happened or haven't happened in these past 5 years.
Thank you, Mr. General. Dr. Jacek, please.
Thank you, Chair. And yes, I'll be supporting this motion. I think that going back to 2010 is actually quite useful. We know that we had H1N1 in 2011, I believe, and around that time period. So it would be useful to understand how the national stockpile was replenished, if it was, the details. We did get some information on that topic through our deliberations as the Health Committee, but I think it would be useful to explore that again in the interest of transparency that has been quoted so many times this afternoon. I think that this would really help in analyzing exactly the status of the stockpile over a longer period of time. So I will be supporting the amendment. Thank you.
Thank you, Dr. Jaksic. Mr. Van Bynen, please go ahead.
Thank you, Mr. Chair. I wholeheartedly agree with the amendment that Mr. Fisher's put forward, and I believe that Dr. Jaksic adds a great dynamic to it. This is not a short-term thing. This is something that's happened over a very long period of time, and in the interest of understanding and making sure that what we are doing is better, and that we will be implementing long-term plans coming out of what we've learned now. I think we need to have a better understanding of our history as well. And so extending the history to include 2010 makes an awful lot of sense to me. And so I will be supporting that motion.
Thank you, Mr. Van Bynen. We go to Dr. Kitchen, please.
Thank you, Mr. Chair. And I'm comfortable with that. I think, though, we should go back right to 2003 when the agency first and the NES was first established, and to see exactly how it was established and how it was monitored. So having that information, I mean, I wonder if the mover would be okay to make that adjustment to make it as of 2003, or does he need a sub amendment to a sub amendment to an amendment to an amendment?
Mr. Chair, I'll speak to that just briefly. You had suggested that there were no friendly amendments earlier. So, of course, Dr. Kitchen has every ability to do a sub-amendment. However, the reason why I chose 2010 is because that was when the purchase of the equipment that was out of date and had to be disposed of was around the 2010 era. It wasn't in 2003 or 2004. I wouldn't mind clarity as well. I don't know exactly when the NES started. I would believe Dr. Jaksic would know that for sure. But the reason I stuck with 2010 is because that was when the products, the masks and the PPE was considered new.
So just to comment on friendly amendments are not strictly part of regular process, but we can generally do things by unanimous consent, which is kind of where that fits in. So it's really up to Dr. Kitchen, I guess, whether he wishes to proceed with an amendment to change that date to 2003. Dr. Kitchen, if you care to step in.
Certainly, Mr. Chair. I mean, I don't want to prolong. We've been definitely rehashing, and that's why I made my amendment to the amendment to the sub-amendment to the sub-amendment. The bottom line is that when NES started, and I agree with Mr. Fisher, I don't know exactly whether it started 2003 or 2004, but I think if it's established the purchase of masks, et cetera, back at that point in time, it would be interesting to see and worthwhile knowing whether it was whether that equipment was actually found obsolete and was it replenished, et cetera. So I'm comfortable. If I'm just hoping that maybe we could why don't we go back to 2005 and do 10 years go back, and if I need to make a sub amendment to that, I will. But I'm hoping Mr. Fisher might say, hey, maybe I can make that change, and we can agree unanimously on that.
Well, let's make the offer. Mr. Fisher, are you comfortable with moving the date to 2005?
Again, knowing full well that Dr. Kitchen can move a sub-amendment, I will stick with the 2010. Again, I've used the argument, and I believe in the argument about putting our public servants to too much effort. I questioned numerous times whether I would actually do the 2010 date, but I do think that when it comes to the National Emergency Stockpile, going back to when that product was considered new is what I would like to get to. Again, Dr. Kitchen has the ability to move a sub-amendment, but I'll support the 2010 date. Thank you.
Thank you, Mr. Fisher. So there will not be unanimous consent here. So Dr. Kitchen, if you wish to move the motion, please feel free to do so at this time. You're on mute.
Sorry, I'm hitting a button and not. Yes, then I'd like to make a sub-amendment to change the date to 2005, please.
All right, so we have a sub-amendment to Mr. Fisher's amendment. Mr. Fisher's amendment was to move the date in relation to the national stockpile to begin on 2010, and Mr. Kitchen has modified that to be 2005. So is there any debate on Dr. Kitchen's sub-amendment? So I'm not seeing anybody's hand go up. Is there any debate on Dr. Kitchen's sub-amendment? Seeing none, we'll call the vote on that. Madam Clerk, if you would please conduct the vote on
Thank you.
Dr. Kitchen's sub-amendment.
Thank you, Mr. Chair. Mr. Fisher.
Nay on the sub-amendment.
Mr. Kellaway.
Nay on the sub-amendment.
Ms. Jacek.
No.
Ms. Sidhu.
No.
Mr. Van Bynen.
Nay.
Ms. Jansen.
Yes.
Mr. Genereux.
Yes.
Mr. Kitchen.
Yes.
Mr. Weber.
Yes.
Monsieur Desilets.
Oui.
Ms. Kwan.
Yes.
Mr. Chair, that is 5 nays and 6 yays.
Thank you, Madam Clerk. So the Mr. Fisher's motion or amendment as further amended is that we take a look at 2005 as a start date for the examining the documents from the national whatever supply. I forget what we're calling this, but are we clear on the amendment? Ms. Kwan, were you speaking?
Sorry, I was just going to say stockpile, but it's okay.
Stockpile. Thank you. Thank you. So the motion before us at this point is Mr. Fisher's motion as amended by Dr. Kitchen. Is there any? I see Mr. Kellaway has got his hand up. Mr. Kellaway, please go ahead.
Thanks, Mr. Chair. I think just in relation to the dates that we passed here, I think September 8th or 7th, I think if we were to go and do this, I think we're going to have to put the date back a bit in terms of the ability for staff to be able to pull the information together.
Thank you, Mr. Kellaway. That amendment, if that's an amendment, would not be in order at this moment. We're dealing with a different matter entirely.
Okay.
So, and I'll have to ask the clerk if it would be amendment, if it would be in order later, since we've already dealt with the dates and times. So, continuing debate on Mr. Fisher's amendment as amended by Dr. Kitchen. As I see Ms. Sidhu, go ahead.
Thank you, Chair. I just want to, because about the date, I want to raise my hand, so I will pass on. Thank you.
Okay, thank you. So, is there any further debate on Mr. Fisher's amendment as further amended by Dr. Kitchen? Seeing none, let us call the question. Madam Clerk, if you please conduct the vote.
Thank you, Mr. Chair. Mr. Fisher.
Yay.
Mr. Kellaway.
Yay.
Ms. Jacek.
Yes.
Ms. Sidhu.
Yay.
Mr. Van Bynen.
Yes.
Ms. Jansen.
Yes.
Thank you. Mr. General.
Yes.
Mr. Kitchen.
Yes.
Mr. Weber.
Yes.
Monsieur Desilets.
Oui.
Ms. Kwan.
Yes.
Mr. Chair, that is 11 yeas.
Thank you, Madam Clerk. So the Mr. Fisher's amendment, as further modified by Dr. Kitchen, carries. So we're back on the main question, which is the motion of Mr. General as subsequently amended several times. Is there any debate on on this main motion? I'm seeing no hands up. Is there any debate on Mr. General's main motion as amended? Dr. Jaksic, please go ahead. So, Dr. Jaksic, you're muted.
Sorry, I guess we're all getting a bit tired. So as a number of my colleagues have mentioned, given the very large number of documents, no doubt, that will be generated by the sub-amendment that we just voted on, or the amendment that we just voted on, taking us back to 2003, I'm wondering if I'd like to propose another amendment in terms of the date of the production of the documents, because how we have it now, I believe, is they are to be provided by the document by August 31st and published publicly on the committee's website by September 7th. So I'm wondering if we could perhaps add a little more time, and I'd like to amend the motion to actually have the documents to be provided by September 30th, and then subsequently published a week later, which I presume would be something like October 6th, 7th.
Thank you, Dr. Jaksic. I have a note from the clerk that says that because we changed the scope of the motion, it would be appropriate to revisit the date. So, Dr. Jaksic, your motion to amend is in order. And we have Mr. Kellaway. Please go ahead.
MP Jaksic took the words right out of my mouth. 15 years of documents and whatnot will require the amount of time that I believe MP Jaksic has put forward. So I'll be supporting that. Thank you.
Thank you, Mr. Kellaway. Mr. General, please go ahead.
I believe you had set precedents for accepting a friendly amendment, Mr. Chair, just a moments ago. I would, if you're still in the mood to accept these types of amendments, I would certainly be open to amending that to account for the large scope and time.
So, Mr. General, are you proposing that we vote by unanimous consent to change the dates as you propose, as Dr. Jaksic has proposed?
I don't know if that's my call, Mr. Chair, but if it is, then sure, I'll propose.
Well, happy to move this along. If we can do it by unanimous consent, I'm happy to do so. I will ask if there's any dissent from accepting Dr. Jaksic's proposal to change the dates.
Mr. Chair, I wonder if I may speak to that.
Certainly, Ms. Kwan, go ahead.
Thank you. Well, I'm just wondering if this would make sense. So I'd like to try this on for size. So we've already moved our original date to the end of August. And now we're talking about end of September. And I understand that the scope of the information has been broadened. How about if we do this? For the latter part of the information that's being sought, and so that is the scope of information where it's been broadened to extend the date for that information to be made available with a timeline of September. And so that is to say, the original part of information that was being sought by the committee, that we still abide by the August 31st timeline. So basically, we're applying two timelines to the information. The original information that's being sought, and for that to be made available by August 31st, and September 7th or 8th, I think it is, for it to be published. And then for this second part, where the scope of the information being sought has been expanded, and for that information to be made available by September, end of September. Mr. Chair, can I try this on for size just so that we can maybe get these the documents in batches?
Sure. Let us take the temperature of the room here and see if there's any will to proceed in this manner. So, is the committee prepared to accept Ms. Kwan's proposal to amend amend the motion to provide the documents in two stages, and the second one being for the national stockpile to correspond to Ms. Jaksic, Dr. Jaksic's dates, and the other documents to be as previously decided August 31st and September 7th. Is there can I have some indication from anybody if they oppose such a perspective?
Mr. Chair, could I just clarify if you're referring to the documents that relate to the period of 2005 to 2020, what I wouldn't want to see is that information relative to the National Emergency Strategic Stockpile first arrive in a bundle from 2015 to 2020. I think all of the documents that relate to that subject should arrive at the same time. So if I could just clarify that,
I believe that is Ms. Kwan's suggestion.
I just wanted to confirm that all of the documents, not just a portion of the documents for the National Strategic Stockpile, would be published early. All of them would be reviewed and recommendations based on all of the information and not partial information.
Yes. So, Dr. Jaksic, your motion was moved and it is in order. This is a substantial change to that. We can attempt to do this by unanimous consent. Would you be agreeable to doing so?
I think I need some further clarification, as Mr. Van Bynen has suggested. Is Ms. Kwan actually saying that the mask information, just to put it simply, would be required by August 31st, and then in the entirety of the NES information, the stockpile information, 2003 to 2020, that's the piece that I was suggesting that the whole package be until September 30th. But you're saying to divide the mask piece with the original dates that we had suggested, that passed, in fact, and then the stockpile piece in its entirety, 2003 to 2020, be available September 30th. Is that what you're
just for
proposing?
clarity, the date was not 2003, it was 2005. But other than that, I think that's exactly what Ms. Kwan is suggesting.
Just a point of order, sorry, I'm really concerned about the translators. I know that we've talked many times about their health when they have to do the translating. So I just want all of us to keep in mind that that's an issue. I don't know that if we have like another team behind them that can switch off with them, but it's a concern.
Thank you, Ms. Jansen. I appreciate your concern. My information is that the translators team basically gives us a hard cap of the top of the hour coming up. I'm not sure if there's another team on deck, but we should probably consider that that's a hard cap for this meeting, and we should probably plan on another meeting, perhaps next Monday, to carry on and finish what we've started here. I think we will, in any case, postpone the in-camera portion for another week. So, getting back to Dr. Jaksic's motion, it may be that we can't it's too complicated to do this by unanimous consent. But let's give it a shot.
So, sorry, Mr. Chair, if I can just interject to the question that was asked. That is correct. That is what I'm asking to the committee's members who were asking that question.
So the proposal here is that we deem Dr. Jack's motion to amend to be as Ms. Kwan has proposed, which is that the entire subset of documents relating to the National Strategic Stockpile be, because of the change in scope in relation to those documents, that the delivery time for those documents be moved to the dates that Dr. Jaksic proposed. Is that your suggestion, Ms. Kwan?
No, sorry. My suggestion was to separate out the two requests with the two separate timelines that was proposed. So the masks request for the timeline to be in keeping with the August 31st timeline that was previously established. But because the scope of the stockpile has been extended by timeline, and that information then be abiding by the suggestion that it be made available in September.
Understood. I thought that's what I said, but it's good to have it clarified. So, Dr. Jaksic, are you comfortable with that?
Yes, Mr. Chair. I think that's logical.
So, I'm not sure. I see Mr. Kellaway has his hand up, but let us just see before we go on any further whether there is. We have unanimous consent to deem Ms. Jack's motion to be as Ms.
Point of order.
Proposed.
I think that Matt got kicked out.
Okay.
I don't see him on here anywhere.
All right. I guess we can wait a couple minutes and ask him and give him time to reconnect.
Oh, there he is.
There he is. Okay. Welcome back, Mr. General.
Thank you, Mr. Chair.
So
it was a good attempt, but I'm back.
I'm trying to ascertain if we have unanimous consent to deem Ms. Jack's motion to be as Ms. Kwan has proposed. And I will. I guess we'll. Is there any dissent for that approach? Mr. Fisher, please go ahead.
I don't know if it's dissent or not, but I wonder, like, none of us really knows exactly what's involved in pulling all this stuff together and how easy that is to do. I think it simplifies things to keep it September 30th, not to, it's if Dr. Jaksic says that she's okay with her motion being amended, I'm happy to support her, but I do have some concern about that time frame and then complicating things by splitting it up.
So that sounds to me like not consent. So we are faced with dealing with Ms. Jack's motion to be subsequently modified by Ms. Kwan, and dealing with that in the normal course of events, or we short circuit the process and do it by unanimous consent. So, Mr. Fisher, would you be amenable to that, to doing this by unanimous consent, or shall we go forward with the full process?
Well, again, my feeling is September 30th is a better time frame for this. Again, I would go with Ms. Jassic's motion. If she says she's okay with MP Kwan's sub amendment, then I guess who am I to disagree?
Okay. So Ms. Kwan did not actually move a sub-amendment. We were trying to do this by unanimous consent. Ms. Kwan, would you like to move that as a sub-amendment?
Sure, I'll move that as a sub-amendment. I think we all heard MP Jassic saying that she accepted that as a friendly amendment. And I think we heard MP Fisher say, who am I to oppose? So I think if really go with that language that was spoken by both members, then I think we actually do have unanimous consent. If that's not the case, I'm happy to move my sub-amendment.
I can't argue with her, with Jenny's logic there, Mr. Chair.
I'm almost dying here. So,
I hear you. All right. So, I'm going to have to take a vote on the unanimous consent because I think there's a certain, I'm not sure that we have unanimous consent. So if the clerk would actually take a vote on whether we in fact have unanimous consent to proceed as we've described, please go ahead.
Thank you, Mr. Chair. So I guess the vote is on whether or not there's unanimous consent. Mr. Fisher?
Sure.
Mr. Kellaway?
Yes.
Ms. Jacek?
Yes.
Ms. Sidhu?
Yes.
Mr. Van Bynen?
Yes.
Ms. Jansen?
Yes.
Mr. Generu?
Yes.
Mr. Kitchen?
Yes.
Mr. Weber?
Yes.
Monsieur Desilets?
Mr. Desilets? Yes.
Juan?
yes.
Mr. Chair, it would appear there are 11 yeas.
Hallelujah.
There you go. Okay, so Dr. Jacek's motion is deemed to have been moved as we've now decided to basically split off this two sets of documents with the national stockpile related documents to be to arrive at Dr. Jacek's later date. Is there any further discussion on the effective motion by Dr. Jacek? And I see Dr. Jacek's hand is up. Please go ahead. And you're muted.
Mr. Chair, I am lowering my hand as we speak.
Thank you. Any further debate on this amendment? Any further debate? Mr. Van Bynen, you have a question?
Yeah, you just referenced an amendment. I thought we were back to the motion as amended.
No, Dr. Jacek moved that the dates on the whole motion for delivery of the documents were changed. Ms. Kwan proposed a friendly amendment that only the dates for the documents pertaining to the national stockpile were changed and that they've been delivered in one fell swoop on the later date. That decision to deal with Dr. Jacek's amendment in that fashion was passed by unanimous consent, but we still have Dr. Jacek's motion on the floor as we have unanimous agreed that it should have been deemed to have moved. So we're still on Dr. Jacek's motion. I suspect we're probably all in agreement of it, but we should, if there is no debate, we will take the vote on it. But if there is debate, we will continue to debate that item. So the debate is on Dr. Jacek's motion as subsequently modified by unanimous consent.
Okay, all right, thank you.
So is there any discussion on Dr. Jacek's motion to amend? Seeing none, I'll ask one more time. Is there any further debate on Dr. Jacek's motion to amend? And seeing none, I think we will call the vote. So, Madam Clerk, if you would please call the vote on Dr. Jacek's motion as amended by unanimous consent.
Mr. Chair, may I please reread the motion as I understand it, just to be clear that I'm capturing everything completely?
Desperately good idea. Thank you.
Thank you. So I do have the dates in two different places in the motion. So here it goes. Pursuant to Standing Order 1081A, the committee sent for the following documents to be provided by the government by Monday, August 31st, 2020, and that the documents be published publicly on the committee's website by Monday, September 7th, 2020. All documents, briefing notes, and memorandums regarding the emerging evidence that altered the government's advice on the wearing of masks, referenced by Dr. Theresa Tam, Chief Public Health Officer, at her appearance before the Standing Committee on Health on Tuesday, May 19th, 2020. and that all documents, briefing notes, and memorandums to, from, between Health Canada, the Public Health Agency of Canada, the Minister of Health's office, the Privy Council, and the Privy Council regarding the management of the National Emergency Strategic Stockpile from 2005 to 2020 be provided by the government by Wednesday, September 30th, 2020, and that the documents be published publicly on the committee's website by Wednesday, October 7th, 2020, including supply inventory broken down by numbers and all updates, and it continues.
Thank you. I think that is the motion. Does anybody have any problem with that clarification? Okay, I think that is the motion before us. So if, on that basis, we will conduct a vote. So Madam Clerk, please go ahead.
Thank you, Mr. Chair. On the amendment of Ms. Jacek, Mr. Fisher.
Yay to the amendment.
Mr. Kellaway.
Yay to the amendment.
Ms. Jacek.
Yes.
Ms. Sidhu.
Yes to the amendment.
Mr. Van Bynen.
Yes.
Ms. Jansen.
Yes.
Mr. Genereux.
Yes.
Mr. Kitchen.
Yes.
Mr. Weber.
Yes.
Monsieur Desilets.
Mr. Desilets?
Mr. Chair, that is 11 yeas.
Thank you. I think it carries. Okay. Now we're back to the main motion as many times amended. Is there any further discussion on the main motion as amended? Seeing no hands, I'll ask again. Is there any further debate or any further discussion on the motion by Mr. General as amended? Ms. Jansen, please go ahead.
Just a quick question. I thought that the other guys were going to ask or put in a new amendment that had the PMO as a separate. Was that not actually the case? As a separate amendment? They wanted it completely separate for some reason?
There was no such amendment. I think the intent had been to deal as separate items, whether or not to include those particular offices in Mr. General's amendment, but they didn't. There was no such amendment.
So they said they were going to, and then they didn't. I just want to be clear.
No, that's
well,
not true.
there was a subsequent amendment to deal with removing the health department from the main motion, and that was not passed. Okay, so any further discussion on Mr. General's main motion as amended? Seeing none, we shall call a vote. So, Madam Clerk, if you would please call a vote on Mr. General's motion as so vigorously amended. Thank you.
Thank you, Mr. Chair. Mr. Fisher.
Happy to support. Voting for.
Mr. Kellaway.
Yes.
Ms. Jacek.
Yes.
Ms. Sidhu.
Yes.
Mr. Van Bynen.
Yes.
Ms. Jansen.
No.
Mr. Genereux.
Absolutely not. Too many amendments.
Mr. Kitchen.
No.
Mr. Weber.
No.
Monsieur Desilets.
Mr. Desilets? Yes.
Ms. Kwan.
Yes.
Mr. Chair, that is 7 yeas and 4 nays.
Thank you, Madam Clerk. So the motion has passed. So we are 10 minutes up, I believe, to an effective hard cap on translator time. I propose that we should resume the discussion on the remaining 3 motions of Mr. General on, say, next Monday. I'll ask the clerk if we can get a time slot. I think the current week is pretty full, at least for me. So I'm hoping we can agree on a early time next week to finish this off. I will also postpone the drafting instructions, which had been plan to follow this public portion until the end of that meeting. So I'm sorry, someone had interjected something.
Yes, Mr. Chair, before we adjourn for this meeting, I just want to make sure that the information being sought will go unredacted to the law clerk's office. So, so I just want to make sure, because last time the February 26th motion that was passed, that didn't actually happen. It was the redacted information that went to the law clerk's office. I want to make sure that we follow the rules and the motion that's passed by committee. So if we can ensure that that happens, that would be great. Thank you so much.
Well, thank you. We can, from this committee, we can do no more really than to pass the motion as we did, and we can rely on the. We will have to rely on the departments to act accordingly. Any more comments?
Just to follow up on that, Ben, I'd be curious to know, in the event that if the departments do not follow through on the committee's motion as they've been passed, what options do the committee have? I wonder if that's something that the clerk's office can endeavor to find out to report back to the committee at our next meeting.
Thank you. I will ask the clerk to do so. So is there agreement that we shall resume this this meeting as soon as possible, say next week? Seeing no dissent, I shall take that as
Mr. Chair.
Oh, Mr. General, I see your hand is up. Sorry.
That's all right. It's been a long meeting. Yeah, I think, obviously we want to get through these next three motions, important motions, I think, for the scope of our study. So yeah, next week would be ideal. If not Monday, at least someday next week would be great. I do just want to take the last few minutes here and wish Karen a happy birthday. She was, I imagine this was probably a opportunity for her, as we're going to go in camera, to really take over the meeting. However, it didn't happen today, but again, happy birthday to you, Karen.
Thank you.
Well, indeed, happy birthday indeed to Karen. And part of your gift is we will not sing to you.
Come on, Callaway.
Yeah. Anyway, all being said and done, I think that we will call that a day. We will schedule another meeting to carry on as reasonably as soon as possible next week. And thank you all. And the meeting is now adjourned.